Good afternoon and welcome to another discussion where we are journeying through the Constitution. If you have been following us from the inception when we started to look at the Constitution of the Cooperative Republic of Guyana, you would have recognized that we dealt with a series of discussions touching and concerning the legislator, and we even went on to talk about parliamentary privileges. Now, because of the fact that we are dealing with separations of power, we want to again remind you that the parliamentary privileges, as well as whether we want to consider the legislators by itself, we want you to always note that it is the legislators who will make and unmake laws. The executive, we are going to, in a subsequent discussion, we are going to look at the roles and the functions of the executive. But I want you to pay careful attention today because I want to begin the discussion today by looking at the judicial branch, or the judicial pillar, as you may want to consider it. Now, in many of the writings from various legal thinkers, whenever they try to consider the importance of the judiciary, they always go down one road, that the judicial branch is a very jealous, guarded branch that you may want to consider. Because once we talk about the judicial arm has very guarded jurisdiction, and guarded in itself, that there ought to never be a situation where any form of outside influence is able to penetrate or infiltrate the judicial system. The judicial system must at all times remain independent and strong. And I will tell you why this is so. You would have heard us begin the talks about these three branches or pillars which are important, which keeps the wheel of the democracy rolling, and that the courts is considered as the guardian of the Constitution. Now, if the court is considered the guardian of the Constitution, you must almost come to the conclusion that whenever we're talking about the judicial or we're talking about the courts, we're talking about this arm or branch which ought to at all times maintain its independence. Now, the doctrine of the separation of powers accords the strongest emphasis to the separation of judicial functions from the executive and the legislator. Now, these are not my words, but I have adopted it because of the fact that it comes out of this very strong case. And I say strong case because of the fact that it has been promulgated in many of the other cases that we have read. The case of the Director of Public Prosecution and Molson. Now, that is a 2003 case, and you can find that case at 64 West Indian Report at pages 140 going forward. Now, in that case, you had a series of reasoning in which the courts, in its main form, came to the very learned conclusion that whenever you're talking or considering the judicial branch, it is very crucial that its independence and its in its strength remains in a democracy. Now, I quote, whatever overlap, and this is the important, one of the important quotes that you can find. Whatever the overlap there may be under the Constitution whenever we're talking about the Westminster models, between the executive power and the legislative power, here is what the court is saying. Whatever overlaps they might be, and we're going to talk in another subsequent discussion, we're going to talk about some of those overlaps. Those overlaps where you will find that the executive and the legislator may very well seem as though they are performing some of a very similar or same function. But sometimes the courts have recognized that sometimes there can be overlaps. But what is important for us to understand is that whatever the overlaps may be, the separation between the exercise of judicial powers on one hand and the legislative and executive powers on the other hand, it must at all times be totaled, and it must effectively be stated that there can never be an overlapping role or function of either of those two other branches with the judicial branch. The judicial branch, because of the by virtue of the fact that it starts and it ends as guardian of the Constitution, they must at all times be able to keep both the executive and the legislators or legislator in check. And so the overlaps which are created sometimes between the executive and the legislator, they create an opening for the judiciary to provide balance. So thereby promoting a rule of law and accountability in government. Now, given these functions of the judiciary, it is very important that other institutions of government should not be able to dictate to judicial officers how to perform their functions, and or even to attempt to undermine the judiciary in any way. That is how importantly the court reasoned in the case of Molson. Now, there's another important case, and you may ask yourself, why are we referring to case laws? The reason we're referring to case laws is because you may not find this type of explanation in the text of the Constitution, or you may not be able to pick up any legislation and or act or statute, whichever one you want to consider it as. You may never be able to turn to the pages and find these types of explanations. And it has been the historical development of the courts that judges have tried their best in their learnings to expand the interpretation and the understanding as to how separation of powers must work or operate. And therefore, in order for you to get reference and for you to get an understanding as to where these types of explanations have come from, we will have to refer to case laws. So another case that you may want to consider is the case of Hines and the Attorney General, and that is a 1975 case. You will find that at 24 West Indian Report at page 326. Now, in that case, again, it was articulated that for there to be a smooth dimension, or for there to be an effective dimension of this separation of powers doctrine, we will have to consider that the courts play a very vital role in keeping that balance between all other branches. All right? So that became very important for us to consider. Now, in maintaining, for the judiciary to maintain its independence and for it to maintain its authority, you will find that the courts have taken responsibility for its own procedures. So you will not find, and for instance, years ago we had the High Court rules, and the High Court rules told an attorney how an action is to be filed, what format it is to be filed, what is the order in which it is to be filed, and what is the section that needs to be claimed. Now, I believe since the year 2016, we have adopted in our own court system the new civil procedures rules, and those rules now have changed considerably how matters are presented to the courts. Now, that in itself is the court or the judiciary or the judicial arm taking responsibility for its own procedures. Now, no outside body, let's say the executive or the legislators, cannot come and tell the courts how they must conduct their affairs. All right? Now, it is separate when you're dealing with law, because the courts, they have a responsibility to enforce the law. And I have said on a previous occasion that if the law, like for instance, we have a considerable contention now with the Cybercrime Act, because the Cybercrime Act seems to be considered used and abused at some points in time. And there are some thinking behind it that one may want to look or take a closer eye to see whether there is a constitutional infringement or that is caused by that act, where one is considering that they have a right to express themselves. Now, at that stage when that act is going to be tested using the constitutional tools, we will then have a determination for that. But I'm saying that to say, until such time, the act remains law. And therefore, we might have a lot of disagreements with that act, with the application of that act. But it is for the courts to enforce just what the law says. So, in the same vein, I am saying, while the courts have a responsibility to control and to be able to set their own procedures out, they cannot jump, the courts cannot jump into the bracket of saying, because they personally, the judge personally considers that the law is a bad law, that we will not enforce the law in our courts. Because if a court were to do that, it means that the court is jumping out of their own functions and mandate, and they're now jumping into the legislator's role in which they are seeking to change law. I will give you another perfect example. Senior Counsel Ramdani, myself, Sanjeev Dattadin, and Attorney at Law Gasai, we stood in the case at the Caribbean Court of Justice, and we articulated the case of Marcus Bisram against the Attorney General and the Director of Public Prosecutions, in which we challenge the powers under the summary, the Criminal Procedure Act, in which impose the Director of Public Prosecution to direct a magistrate to commit someone, even where the situation, even where the magistrate has formed the opinion that there is insufficient evidence to have committed the person. Now, we challenge that. Now, the ruling, if you were to carefully dissect the ruling of the Caribbean Court of Justice, you would recognize that that case did not change the law, because the Caribbean Court of Justice couldn't say this law is unconstitutional, it's outdated, it is not in keeping with the development of the jurisprudence and law in the Commonwealth Caribbean, therefore you are not to follow that law. What the case did and what the court did is to put a hold on the operationalizing of that section and the provisions of the Director of Public Prosecution until such time as the legislators would change the law. So you need to understand that even where the court forms the view that a law is not a law that ought to be ought to be operationalized or ought to be functioning in a court, they cannot jump out into the legislative's role and change the law, because the courts cannot make law. The courts cannot unmake laws. So any law that shuts down a piece of a legislation, that bad piece of law remains on the books only until that time as the legislators go to Parliament and change the law. And that is the importance of understanding roles and responsibilities and functions of these various branches that I have identified. So each branch has its own role and function, and that there should never be an interference or the judicial decided one morning that I'm going to jump up and I'm going to declare in the Republic of Guyana what is now law. It will not be that that type of operations. And one of the greatest thinking or justification as to why the separation of powers need to always be considered very pivotal is because it keeps the wheel of democracy rolling. If we have a situation where everyone jumps into one another's role and function, and that there is no respect for your own function and responsibility, we can have chaos in society. So that the legislators in order to guarantee a particular outcome of a law will have to take responsibility to make the law of itself, and then have the courts enforce the law. Because really and truly, if you were to agree with me, then we will both say that the courts must enforce the law. All right, so the court is an enforcer of the law. Now, in a next week's discussion, we are going to develop these points a little more, and we're going to specifically look at how the legislator or the legislative branch and the executive branch, how they can work together without crossing paths in relation to their roles and functions. And then we are going to come back, we're going to examine some cases or some scenarios in which there can be a crossing, or there can be the appearance of crossing. And then we will come back to examine how the courts will treat with those circumstances. And we will see the importance of keeping the judicial branch independent and strong. I thank you today.